Welcome, everyone. Thank you so much for joining us for today's Lunch and Learn, Reform Through Resignation, Why Chief Justice Roberts Should Resign in 2023. Many proponents of reforming the Supreme Court have expressed support for adopting a system of 18-year staggered term limits. These proposals, however, are hobbled by constitutional constraints. Amending the Constitution to implement term limits is highly implausible, and implementing term limits through statute is likely unconstitutional. These constraints appear to doom the otherwise desirable proposal to limit the Supreme Court justices' terms of service. But there is an alternative path. Professor Scott Bloomberg of Maine Law has recently published a law review article proposing that Chief Justice John Roberts is uniquely positioned to create a norm of justices resigning after serving 18 years on the court. Just as George Washington's decision not to seek a third term as president established a long-lasting presidential term limit norm, the Chief Justice could do the same for the Supreme Court. Professor Bloomberg, we cannot wait to hear all about this. Thank you for joining us. My name is Kathleen Neal. I am Director of Policy and Partnerships here at Maine Conservation Voters, Maine Conservation Alliance. Our organizations represent more than 10,000 members and supporters dedicated to protecting Maine's environment and our democracy. MCA does that through education, collaboration, and advocacy, and MCV by influencing public policy, holding politicians accountable, and winning elections. A few technical notes for today. We will hear from Professor Bloomberg and then tackle questions in the Q&A session at the end. You don't need to wait, though. You can send your questions to me through the chat whenever they occur to you. I'll keep track of them and ask Professor Bloomberg at the end. If you have any questions, you can message Will, or I'm sorry, if you have any technical difficulties, you can message Will Sedlak through the chat. This event is being recorded and the video will be posted on our website later this afternoon, where you can also find recordings of all of our previous Lunch and Learns. Thank you again for joining us, and Professor Bloomberg, I will turn things over to you.
Well, thanks, Kathleen, and thank you so much to Kathleen and Will for reaching out to me to organize this. And thank you to all of you for being here. I mean, for an academic like me, there's really no higher compliment than like somebody else being interested in something that I've written, especially when someone else is not another academic. So I'm just so glad to see you all here. And I'm just excited to talk about this. So like Kathleen said, I think Chief Justice Roberts should resign from the Supreme Court next year. And it's not because like I'm not a fan of the Chief Justice, which I'm not. I find myself often disagreeing with his opinions or opinions he's joined, and sometimes very vehemently disagreeing with those opinions. But that's not why I want him to resign. In fact, if he was my favorite justice of all time, Louis Brandeis for the record, I would still want him to resign next year, because next year he will have served 18 years on the Supreme Court. And I think that's how long Supreme Court justices should serve. So Kathleen said a little bit about why I want him to resign after 18 years, but let me spend some time elaborating on that. So Article 3, Section 1 of the Constitution says that the judges, both of the Supreme and inferior courts, shall hold their offices during good behavior. And this clause is known as the Good Behavior Clause, and it's universally understood to confer life tenure on federal judges. They hold office until they resign, they die, or they're removed through the impeachment process. And I want to point out right at the beginning that this life tenure system is incredibly unique to the United States, and in fact is incredibly unique to the federal judiciary. No other state in the United States and no other major democracy on earth has this system, right? Other governments have terms, right? Judges serve a term. They have mandatory retirement ages, like judges have to retire when they hit 70, or they have judicial elections. Some states have judicial elections, right? And there are some benefits and there's some drawbacks to this system of life tenure. So the benefit, right, the main benefit is that it ensures judicial independence, right? That's independence both from the other branches of government, right? It can't be controlled by Congress or by the president, and from the will of the majority, right? We like to think of the court, one of the functions the court is supposed to serve is to check the majority, to provide a counter-majoritarian check so that if the majority is trying to oppress the minority, right, the court is there to protect the rights of the minority, right? And it's easier to do that if the court is insulated from the democratic process, like it doesn't have to worry, justices don't have to worry about being reelected, for example, right? And the other benefit of life tenure is that it provides doctrinal stability, right? The law is less likely to go through drastic changes based on judicial interpretation if we have the same or roughly the same group of people interpreting the Constitution and interpreting statutes over a long period of time. If you have, say, a rotating cast of judges every 2 years, 3 years, 4 years, you might find the law changing a lot more, and that might be disruptive to states, to local governments, and to private actors who depend on some stability in the law. But right, despite these benefits of life tenure, it's just not clear to me that life tenure is actually necessary to secure these benefits, right? Like a mandatory retirement age would do the same thing, and a term limit, right, at least of sufficient length, would do the same thing too, right? It would create enough stability that the law remains relatively stable over a long period of time, and it would secure independence for the court, right? They wouldn't be subject to the whims of a democratic majority. And more importantly, right, life tenure carries some pretty significant downsides. And these downsides have gotten more and more significant in recent years. So the first is that, like, the strategic timing of retirements, justices strategically timing their retirements, and the uncertainty and happenstance of death can create real significant inequities in how many judges a given president gets to appoint. So if we're looking at historic examples of this, right, President William Howard Taft appointed 5 justices to the Supreme Court in a single term as president, the majority of the court in a single term. President Harding appointed 4 justices in just 2 years, 2 years before dying. He appointed 4 justices. More recently, right, we have President Clinton, President George W. Bush, and President Obama, who each appointed only 2 justices over their 2 terms in office. And then we had President Trump, who appointed 3 justices in just 1 term in office, right? And indeed, right, the situation with President Trump's 3 appointments, as you all know firsthand, was very controversial. What with the holding up of Merrick Garland's confirmation, and then the appointment of Neil Gorsuch, and then Ruth Bader Ginsburg's death, and the appointment of Amy Coney Barrett. This has caused, like, many Democrats to question, right, the current conservative majority on the court, the legitimacy of that majority in light of some of the let's say mischief around those appointments. And also the just imbalance, right, of Democratic president Barack Obama serving for 8 years and only getting 2 appointments, and then a Republican president getting 3 in just 1 term. right? So that's one set of problems with life tenure. And the other set of problems is that the terms of service for justices are getting ridiculously long. Like, justices are being appointed at younger and younger ages, and life expectancy is increasing. And so justices might be serving for like 40 years on the court. And indeed, the three justices appointed by President Trump were all around 50 years old or so at the time of their appointment. And they might well serve for 40 or more years, right, with increasing lifespans. And, you know, this is problematic, I suppose, for several reasons. But one reason is what I call the democratic attenuation problem, right? And the idea here is, you know, courts need to be independent from the whims of a democratic majority for the reasons I talked about earlier. But at the same time, courts get their legitimacy from, at some point, having been appointed by representatives of a majority of the people, right? They're supposed to be appointed and confirmed by a president and a Senate that ought to represent a democratic majority, right? And then that democratic majority is effectively saying, we trust you, we trust this person, right, to interpret the Constitution, to be on the highest court of the land. And the further and further the court collectively gets from that point at which a democratic majority entrusted them with this position, right, confirm them to this position, the less claim they can make to that democratic legitimacy, right? Now, none of this is super problematic if you think that constitutional interpretation is a purely objective task, right? That is, like, if you think there's some method of interpreting the Constitution that produces objective, determinative results, then the identity of the justices or how long they serve on the court doesn't really matter, right? As long as they're applying that objective, determinative methodology in interpreting the Constitution, then it doesn't matter who they are, right? And that is what some originalists believe, right? Some originalists, not all, but some, especially kind of like in the general population, people who would identify as originalists, believe that a judge can simply look to the original meaning of the text of the Constitution, and that original meaning will supply an objective answer to every or most every constitutional questions. And if you think that, then who cares who's doing the interpretation, right? Because there is an objective answer. And as long as they're applying that methodology, it doesn't matter who they are, right? But I don't think it works that way. I think that regardless of what method of constitutional interpretation a judge subscribes to, there's a good deal of subjectivity that goes into interpreting the Constitution and into applying that interpretation to the wide variety of factual scenarios that come before courts every day. I think judges have to make judgments. They have to make subjective judgments about the meaning of the Constitution as applied to a wide variety of cases. And if you believe that, as I do, then the identity of the judges matters a lot, and how long they serve matters a lot. So for me, and for people who think like me about this, life tenure for Supreme Court justices is incredibly problematic, right? It's not good to have the same people making subjective judgments about the Constitution for 40 plus years. And it's not good to have the identities of these people decided by the whims of life and death and by strategically timed retirements, rather than by a system that more accurately reflects like democracy, right? And so I'd like to see the US adopt a system where the justices of the Supreme Court are subject to a term limit. And I'm not alone in this, right? Term limit proposals have been written about in legal scholarship for at least 35 years and probably longer than that. And the most common proposal for term limits is one where the justices serve an 18-year term limit. So why 18 years? It's basically a question of math, right? There are 9 justices. And so the math works out pretty well. If you have 18-year terms and you stagger them, that means you get a new vacancy every 2 years. And so each president gets to appoint 2 justices per term. And there's always provisions, if you read some of these proposals about 18-year term limits, there's always some provisions to deal with like what happens when a justice dies or resigns before they reach the 18-year mark. Usually the president would appoint someone to fill out the remainder of that term, or the most recent retired justice could come back and serve out the remainder of that term. There are mechanisms like that in place. But here's the problem, right? Great idea, 18-year term limits, right? But here's the problem. So remember, Article 3, Section 1 of the Constitution, the Good Behavior Clause, gives federal judges life tenure. So how do you impose term limits on the Supreme Court justices without violating that clause of the Constitution? So one option is to amend the Constitution. And I say good luck with that, right? Amending the Constitution requires 2/3 of each House of Congress plus 3/4 of the states. And to say that it's unlikely that a bipartisan consensus will develop around Supreme Court term limits, particularly when conservatives have control of the court for what seems like the indefinite future, to say that that is unlikely, I think is an understatement, right? I hope I'm wrong about this. Like, I would love to see a constitutional amendment that implemented a system of term limits, but I just think that's probably not going to happen. In fact, I think that's exceedingly unlikely to happen, right? So if constitutional amendment is highly implausible, right? The other option is to try to design a term limit statute, like a federal law that Congress could pass, that would impose term limits without violating the Good Behavior Clause. And so how do you do this, right? So the way a few scholars have proposed doing this is by saying that after 18 years of service on the Supreme Court, a justice becomes a senior justice, and their duties are basically limited to filling in for an active justice, right? Which would be the 9 most junior justices. They would be filling in for those justices whenever the active justice has to recuse, like due to a conflict of interest. And they would have a few other responsibilities as well. And they kind of be like the pinch hitters of the Supreme Court, right? When the starting 9 can't participate for some reason, a senior justice would step in. I really like that baseball analogy because there are 9 members of the Supreme Court. It works out really well because there are 9 people who hit in a baseball game too. So if you like, so this is like the idea, right, for how you circumvent this life tenure problem with the statute. You basically make the senior justices pinch hitters. But when you really like scrutinize that proposal in light of the Good Behavior Clause, it almost certainly violates that clause, right? It kind of falls apart under scrutiny because the proposal effectively removes the justice from their office, right? It takes away, right, all of the kind of core responsibilities and powers that the justice has. And since it's taking away those core responsibilities and powers, it very likely violates the principle of life tenure, right? The principle that the justices serve in their position as a justice of the Supreme Court until they are removed through impeachment, resign, or die. So imposing term limits through a statute is likely unconstitutional, and imposing them through constitutional amendment is extraordinarily unlikely. And that's usually where the conversation around term limits ends, right? In fact, you might have heard about this commission on the Supreme Court that President Biden put together maybe 9 months ago, something like that. The commission was comprised of over 30 law professors and lawyers, which is a terrible recipe to get anything done. It's hard enough putting like 3 lawyers in a room and telling them to get something done. I can't imagine being on a commission with 30 lawyers and law professors and trying to get everybody to come to a consensus. But that was how this commission was comprised. And they recently issued a report on the Supreme Court, because that's what commissions do. They issue reports, right? And one of the things that the report said was that most of the members of the commission agreed that term limits would be a good thing, that the most common proposal for term limit was 18-year terms, but that you would need a constitutional amendment to implement term limits. And that was sort of the end of that discussion. So I was thinking, a little over a year ago, I was thinking about these 2 highly implausible options for implementing term limits, right? And I started to think a little bit about George Washington, right? George Washington served 2 terms in office as president and then declined to seek a 3rd term. And then Thomas Jefferson followed Washington's lead, and he declined to seek a 3rd term in office as well. And this norm of serving only 2 terms as president persisted for over 150 years, right? And this term limit, it didn't derive from the Constitution, right? It wasn't in the text of the Constitution that presidents can only serve 2 terms, but it became, like in a sense of the word, it became constitutional, right? It was part of how we as a nation were constituted, part of the way we did things, right? Our presidents only served 2 terms. And when President Roosevelt, when FDR violated this norm 150 plus years later, right? We saw fit to amend the Constitution to formally add the term limit, right? That's the 22nd Amendment, right? Presidents can only serve 2 terms. So I was thinking about George Washington, right? And I thought, why can't that happen for the Supreme Court too? So here's the thing about that, right? It's hard. It's hard to start a new norm because people won't necessarily follow you, right? You've got to be a person with like a certain level of influence, a certain level of moxie, right? To start a new norm. And George Washington, he had moxie, right? Everybody respected George Washington. He was the leader of the Continental Army. He was the first president. George Washington, you know, and Thomas Jefferson, he had moxie too, right? And so let's call this the moxie requirement. You need a certain level of moxie to start a new norm, right? And I like talking about moxie in front of a group of Mainers because like Mainers love the soda moxie. And so I use that word very intentionally, right? And so usually the moxie requirement, right? The need to have a certain level of gravitas to start a new norm, this would be like a major impediment to establishing Supreme Court term limits through changed norms, through a justice resigning after 18 years. Like if some random justice like Samuel Alito, right, decided that he was going to resign after 18 years to try to start a term limit norm, I'm not sure his colleagues would follow him, right? They might just be like, okay, Sam, good luck with that, you know? And if someone like Antonin Scalia or Ruth Bader Ginsburg tried to do the same thing, I think they both had a lot of moxie with their wing of the court, and people in their wing of the court might have followed them, but their moxie with kind of the court as a whole might not have been sufficient, right, to persuade folks on the other side of the proverbial aisle to follow the lead on the norm that they were trying to create. Now, I'm not saying Chief Justice Roberts is George Washington, right? But he's got a certain level of moxie, right? So let's break that down a little bit, right? So even if you disagree with his opinions, which, as I said, I very often do, there are a few things about him that are pretty undeniable, right? First of all, he's the Chief Justice. He's the chief, right? It gives him a little bit more pull, a little bit more gravitas from an institutional perspective. Second of all, he's toward what is now the ideological center of the court, right? He's not at one of the extreme wings of the court. So, even though the liberal wing of the court often disagrees with him, there's probably a level of respect there that's not present with someone like Samuel Alito. Not to continue to bash Samuel Alito, but why not? And third, right, Chief Justice Roberts is seen as an institutionalist, right? He's seen as someone who cares deeply about the Supreme Court as an institution. And so if he does something that he says is needed to do to protect that institution, I think his colleagues will take it pretty seriously, right, on kind of both sides of the ideological spectrum. So he might have the moxie to start a term limit norm by resigning after 18 years, right? I can't say for sure, like to be honest, I can't say for sure that he would, but he might, right? And I can't say that he would want to resign after 18 years of serving on the bench. He has, in the past, he has expressed support for term limits, and surely he must understand the problems that come with life tenure, and he must be somewhat concerned about the court's legitimacy in light of recent events. And it would also create a pretty incredible legacy for him if he did this, right? It would truly put him in the pantheon of historic Supreme Court Chief Justices. And I think he probably cares about things like that. On the other hand, it's a pretty extraordinary thing to do, to like voluntarily cede the kind of power that he has. So maybe he wouldn't be interested in doing this. I can't say for certain. And I also can't say for certain, right, that his colleagues would follow him if he did resign, right? I don't know, like maybe there is a Thomas Jefferson type figure on the court who would be the next to resign, who would follow his lead. And maybe others would follow after that, but maybe not, right? But even with this uncertainty, it seems to me that it's just as plausible, and maybe more plausible, that this could play out in a way that creates a term limit norm as it is to amend the Constitution, to convince 2/3 of Congress or 3/4 of the states to amend the Constitution. It seems like this option that I am suggesting to create a term limit norm is just as plausible as that, right? So I say, why not give it a shot, right? And to quote the last paragraph of the article that I wrote on this topic, I add to the existing menu of statutory and constitutional reforms a different approach. Convince Chief Justice Roberts that the best way to strengthen the institution he cares so deeply about is to resign after 18 years and to persuade his colleagues to follow suit. That pathway to term limits, at the least, seems no more tortuous than the others. So that's it. That's my idea about term limits, and I'm happy to take any questions that folks may have.
Professor Bloomberg, thank you so much. That was fascinating, and you've got me ready to sign up for more law school lectures. Thank you. We are going to share in a follow-up email later this afternoon the link to today's recording, but also the link to Professor Bloomberg's journal article, Reform Through Resignation. So if that quote from the final paragraph caught your attention, just wait. You'll be able to read the whole thing soon. And though we didn't talk about the specifics of any cases before the court today, I will remind everybody that the composition of the court matters on every issue that we care about. So we will also share a link to help you dig into one of the cases the Supreme Court will consider this session, West Virginia versus EPA. Could have profound implications for environmental protection and definitely worth exploring. All right, let's get into some questions. This feels really unrealistic. I know you're right that it's not maybe less realistic than any of the other options on the table, but give us a little insight. What's the value in pursuing an academic argument like this? Or is this a real argument? Should we really be writing letters to the Supreme Court right now saying, Chief Justice, we read this great article. Here's our suggestions.
Yeah, it's a great point. And honestly, I don't disagree with it. Like the point of this article in part, right, is to note that there aren't a lot of realistic options. Like life tenure, the fact that life tenure is in the Constitution creates somewhat of a bind for fixing the problems caused by life tenure. And my point simply is that, look, if we're going to talk about some moonshots, right, we're going to talk about amending the Constitution, we're going to talk about passing a statute and then convincing the very justices who would be forced to resign under the statute that, in fact, the statute is constitutional, then let's talk about like this other option too, right? Because, you know, at least this one has worked with respect to the presidency. It worked for 150 years. You know, and so why not give it a shot, right? And I think kind of the other part of that question, Kathleen, is sort of like, who is my audience for this? Because, you know, who, like, are we all going to submit letters, as Will suggested to me yesterday, to Chief Justice Roberts' summer home, if we could even find that address? Like, I'm not sure that's the right tact, but like when you put something out in a law review, you're hoping that other professors and other people who read law review articles, like, you know, maybe law clerks or judges or prominent lawyers, will see it, right? And so my hope in writing this article is like, hey, maybe this will get to the desk of Chief Justice Roberts at some point. Probably not, but like it's possible. Or maybe it'll get to somebody who's more influential than me. Like I'm just some junior schmuck faculty member, right? Maybe it'll get in the hands of some fancy con law professor at a bigger school, and they can amplify the message. And that's kind of, sometimes that's how change happens, right? And so that's kind of my take on that.
What a good reminder. We don't know where those moonshot ideas will end up and what their path will be. What kind of reaction have you gotten so far?
Yeah, so most of the people I've talked to about this really like the idea, but they respond with exactly what your first question was, which is like, this seems pretty implausible. And then I reply by saying, yes, all of the options are implausible, but let's try this one too. The one thing I would say that I'm kind of disappointed that the Supreme Court Commission didn't talk about this at all. I didn't give testimony in front of that commission. I wasn't asked to. I didn't submit a written comment, which in retrospect, I kind of wish I did. But I was sort of hoping like, hey, maybe somebody will see this. And I tweeted a little bit about it to some people on that commission. I was thinking, maybe they'll mention this as an option when they're discussing term limits, but they didn't. And so that was a little bit disappointing for me.
So you mentioned they did talk about term limits, but they didn't really wrestle with how they would come about given the constitutional constraints?
Yeah, I think they said, I'm trying to recall exactly, but they mentioned that it would likely require a constitutional amendment to implement. And the commission overall, they didn't really, I think they agreed to some minor reforms, or they found consensus around suggesting some minor reforms, but kind of the big ticket items like term limits, they didn't really have concrete suggestions on.
That's certainly the takeaway that I had as a completely uninformed reader. Maybe not completely, but that they sort of threw their hands up and said, wow, everything's broken. Good luck.
Something like that.
So, okay, so let's bite. Let's play it out a little bit. I really appreciated your explanation of why 18 years and that every other year sort of predictability of we just cycle of new justices on. I didn't map out how it would work out, but does that mean we would always be appointing a Supreme Court justice in an election year? I feel like that hasn't worked out well for us in recent history.
So I mean, I guess you could time it so it's on the off year if you wanted to do that, like every first and third year rather than every second and fourth year. But you know what? The other thing I would say about that is that contentiousness around Supreme Court appointments is a good thing. And I don't mean, and I want to be clear about what I mean by that, right? I don't mean that confirmation proceedings should be like mean-spirited. I don't mean that you should have the sort of mischief that McConnell and Senate Republicans had around kind of holding up Merrick Garland's confirmation and then rushing through Amy Coney Barrett's. But I mean that, like, when somebody is appointed to the Supreme Court by the president, there should be a whole lot of scrutiny around that person. And if that person has views that one of the major political parties in this country feels are not great, right? Then it should be contentious. I mean, that person should be subject to scrutiny on their views, because they're going to be one of 9 people who gets to be the final arbiter of what the Constitution means. And whether that's for life, for their life, or for 18 years, like, that's an important job. And you know what, if it's in an election year and it brings attention to the sort of person that the president's appointing, that senators are confirming, then good, because that's like an important part of those representative jobs, and people should be aware that their vote matters, right? Their vote matters because it determines who gets to be on the Supreme Court.
Very good case. How incredible would it be if people really understood all of the impacts of their vote and all of the potential that they have to influence the way things go in this country. So that brings us to I like where we're going, but the getting there feels fraught and a little bit anxiety producing. Is there a risk that while we're in the establishment of that norm phase, some people don't follow the norm? We've heard a lot in the last few years about, okay, maybe we need fewer norms and more laws. Is this just because that's what's available to us, or do you think there's value in a norm that perhaps supersedes the value of a law?
Yeah, it's a good point, right? So the concern, right, is that this norm starts and then somebody breaks it and then the norm falls apart and then we're right back to where we are currently, right? So I think the likelihood that a norm will be broken depends on the strength of that norm, right? And so if the norm is started by Chief Justice Roberts, who's generally a respectable figure, and then if it's subsequently followed, right, the big test will be like, will the first person follow Chief Justice Roberts? Then will the third person follow those first 2 people, and so on, right? And the more people who do this, the more justices who kind of resign in order, the stronger that norm gets, right? And, my thought on this, right, is eventually if that norm gets so entrenched, then one of two things could happen if somebody breaks that norm. One, right, it could lead to a constitutional amendment, like what happened with the presidency after FDR, where people said, you know what, we want this norm was broken, but we want this to be part of the Constitution. And we were able to get, 2/3 of Congress and 3/4 of the states to add that to the Constitution. And the other thing that could happen if the norm is sufficiently entrenched and then is broken is that maybe Congress would try to impeach, right? Would try to impeach that justice under the guise that the justice is not in good behavior at that point in time, right? They violated such a deeply entrenched norm that they're not in good behavior anymore. So those are two positive ways that the situation could resolve if somebody breaks the norm. The negative way it would resolve is that neither of those things happen and the person continues to serve and the idea falls apart. And we're right back to the same system we have today.
But hard to imagine being worse, right? Is in terms of the intractability of the court. So who would be the next person to follow the Roberts example? Who's next and what do we do about the folks who have already passed that 18-year mark?
Yeah, so if you go based on the seniority of people on the court, the next would be Justice Thomas and then Justice Breyer and so on down the line. And it's hard to predict, right, what they would do. It's hard to predict if they'll be on the court in 2025, which is when that would come up. But that's kind of the line of succession as it is.
Do you imagine that this would filter down or filter through the rest of the federal judiciary? Is there a need for term limits at other levels of the judiciary?
That's great. It's a great question. I don't think there is. I think that, first of all, holy moly, that would create a lot of appointments for every president to fill. There are something like over 1,000 federal judges or whatever the number is. But also, the kind of constitutional calculus is different because those judges, while they have very important roles, they're not the final arbiters of the Constitution. They don't have the same impact on our government as do the justices of the Supreme Court. The other thing is that, after a Supreme Court justice retires, if they do retire, they often continue to serve as federal judges and hear cases at the circuit court level. And I imagine that is what would happen under the system I'm proposing as well. So just for example, right, Justice Souter routinely hears cases with the First Circuit. Justice O'Connor did the same. Justice Stevens, I think, did the same as well. So that's Supreme Court justices, even after they retire, do continue to serve on the federal bench often, but just not in the same capacity.
That's really interesting. I've heard that offered as one of the sort of logical conclusions of term limits and didn't realize that it was actually already happening. So there's an example of how norms might be adopted. What else are you thinking about? What other, keep challenging us. How else can we improve democratic participation and political and social equity?
Well, you are all doing the right thing already, which is vote and encourage others to vote, right, and organize. That's the most important thing. If anyone could convince Senator Collins to support the For the People Act, that would be a wonderful thing as well. It's a very, very important piece of legislation. But I don't know. Hopefully it'll pass, but we'll see. But
was there anything else in that came out of the commission as far as Supreme Court reform that you like the looks of or the prospects for?
I don't know, not really, to be honest. I think short of term limits, there's nothing that gets to some of the fundamental problems that the court has. I think a lot of it is just tied to life tenure. And until you get away from that, everything else to me is kind of small potatoes.
this may not be your area of expertise, but what do you think about state courts here in Maine? Are there things that we need to be on the lookout for or thinking about reforming?
Yeah, I don't know. I'm not, to be honest, I'm fairly new to Maine. I've lived here twice. This is my second time living here, but I just moved back in 2020. And before that, I was only here for a year. So I'm definitely not an expert on Maine's court system. My boss is, Dean Softly, former Chief Justice Softly is an expert on that. So she might have some thoughts there. I would say for states more generally, states should get away from judicial elections. I think that's a poor system of selecting judges. I think it's hard for judges to be independent in that system. I think their qualifications are not tested as well in that system. Yet several states continue with this system that I think is quite bad.
Barring any actual change of justices. So if we've got the 9, we've got. Do you see any possibilities about the court becoming more balanced in its approach, or any way that it could? We just feel it feels so political and so polarized right now. Give us some hope here.
Yeah, it's hard, I mean, I think, this is just sort of my opinion, but, and maybe reading the tea leaves, but you've seen in some cases, you've seen Chief Justice Roberts express some institutional concerns about the court, right? Certainly in the SB8, the Texas abortion law cases, you saw Chief Justice Roberts talk about the problems with states trying to circumvent people's constitutional rights, even though he probably disagrees with the existence of that constitutional right. He is concerned that the court was too lenient with Texas in at first not staying Texas's anti-abortion law, and then in kind of giving Texas a bit of a map on how to insulate that law from pre-enforcement challenge in the future if they were to amend it. So maybe you see him starting to shift the center of the court a little bit to the left. But then again, he's not really the center of the court anymore. It's like Gorsuch or Kavanaugh, depending on what the issue is. And they're pretty far right. I mean, they're pretty far right. That's just what it is. So I wish I could be more hopeful, but I'm not. And unfortunately, I think with the composition of the court, we're going to get what we're going to get. And let me say one more thing about that, though, right? And this is something that my colleague Dimitri Baum is big on stressing, and I think it's an important message for this audience in particular. Right? States can go beyond what the federal Constitution requires, right? If the federal Constitution protects, only if the Supreme Court interprets the federal Constitution to say not protect a woman's right to choose, a state can go beyond that and preserve that right in their own constitution, right? And state constitutions are often a pretty overlooked source of rights, right? But they're an important source of rights, right? And so that's something to think about, right?
Without the norm of term limits, justices are left now with a sort of political calculation of I'll resign now because I like who's in the White House and who would replace me, appoint my replacement, or I'll hang on just a little bit longer because I don't like who would replace me. With that sort of introduction, anybody else you think maybe should retire coming up?
Who are you talking about, Kathleen? I just can't figure it out. Should Justice Breyer retire? Probably. Yeah, probably. I mean, I think so first of all, I think there's some chance he will. I also think like from an institutionalist perspective, I think he is concerned about this practice of strategic retirements. But like, it's a bad time to, I think it's just like a bad time to like plant your flag in that ground right now. Because, you know, no offense to him, he's just not getting any younger. I think he's a terrific Supreme Court justice. I really do, especially in areas I care about, like the First Amendment. I think he's just fantastic. But yeah, I think probably this would be a good time.
Speaking of areas we care about, what do you think the prospects are for climate and conservation issues with the current court, and how might that change if Chief Justice Roberts were to resign, or if Justice Breyer were to retire? What are the prospects?
Yeah, so I guess first of all, I'm certainly not an expert in environmental law. My colleague Anthony Moffa or Heidi Robertson would probably be able to speak more intelligently on this than I can. But I would say more broadly, you know, there's certainly a school of thought in conservative interpretation of the Constitution and on the conservative wing of the court, that executive agencies have too much power, that they sometimes exercise their power in unconstitutional ways, or in ways that are not justified by the statute that created them. And this is frequently like something that leads the court or federal courts in general to strike down things that the EPA does, right, for example. And so I think you might see more of that.
One of the really fun things that we get to do in these Lunch and Learn programs is get a little bit of a window into the work lives of different people. So what else are you working on? What's next for you? Have you already started your next law review article, or? Yeah,
so right. So Maine law is a small school, which means I wear a lot of hats, and that's fine. I like the hats that I wear. I teach cannabis law, I teach privacy law, I teach First Amendment, and I teach constitutional law. And I write about many of those things. I've written a bit about cannabis law and the Dormant Commerce Clause, which is way too long of an explanation to go into in the time we have left. I've written a bit about privacy law in Maine. And the next thing I'm working on involves political advertising in the metaverse. And to break that down a little bit, the metaverse is this kind of fancy and kind of silly thing that Facebook is going to invest billions of dollars into, which is basically like an immersive reality environment, right? You put on a headset and you're in an immersive reality, virtual reality environment. And there's some scholarship about how, and my gosh, this is going to sound so dystopian, but there is some scholarship, right, about how the technology needed to create this sort of immersive environment collects a lot of information about your body, right? It can collect information about where you're looking, how dilated your pupils are, what your heart rate is, what your hands are doing, things like this, right? And some scholars have expressed concern about how this could be used for targeted advertising, right? So like you look at a red car and all of these sensors detect that, oh my gosh, Scott really likes red cars. Then you start seeing ads for red cars, right? And so I worry about how this could be applied to political advertising, and also like what the government can do to stop that. Right, there could be some arguments that using information to create speech, to create political ads, is protected by the First Amendment, and I think that would be really problematic, right, if a court were to say that. So so that's kind of what I'm exploring right now. I don't really have like a concrete thesis other than this seems problematic and I want to find a way to prevent it, but that's what I'm working on.
Well, you've convinced me to add law journals to my regular reading list. I can't wait to hear what you settle on, because I agree that sounds problematic, and you're far better positioned to take it further than I am. So let me know what you figure out. Thank you so much for joining us today. It has been just an absolutely fascinating conversation. Thanks to everyone who joined us today. As we said, we'll send out a link later this afternoon with the recording, the link to Professor Bloomberg's article, and a little bit more about some cases that matter to us that are coming up in this session. I hope everyone will join us next week. We will be hosting Heather Deese, who is the Director of Policy and Regulatory Affairs at Dandelion Energy. She's going to talk about geothermal technology for home heating and cooling, and how we can electrify everything as we transition our buildings off of fossil fuels. Geothermal is getting more and more realistic, and Heather will explain exactly what that means for all of us here in Maine. Until then, have a wonderful weekend. Professor Bloomberg, thanks a million for joining us. To all of you, we will see you again soon.